Got so low last night. Hasn't been that good.
Thank you. You're ready now, Judge. Mr. Ambrosi. Thank you. This is docket 98-73777-FC. People of the State of Michigan versus Sean Virgil Brown. Counsel, your appearance for the record.
Elizabeth Allen on behalf of the people, Your Honor.
So Ronald Ambrose appearing on behalf of Mr. Brown.
Thank you. Mr. Brown, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
You may put your hand down. Have you had enough time to speak with your attorney?
Yes.
Have you taken any medication yesterday or today?
No.
Is there supposed to be medication that you should be on, but you're not?
No.
Any sign of fever, COVID, or other illness?
No.
And you had enough time to speak with your attorney today?
Yes, ma'am.
All right, I don't know if we're going to address you today or not, but have a seat. We're going to proceed with the attorneys first, all right? Thank you.
Thank you.
And this is pursuant to the change in law, a resentencing. On behalf of the people, would you like to address the court? And is there a victim here?
Your Honor, I have a couple things first. The victims are not here. I will be speaking on their behalf. But also, so I've spoken with Mr. Ambrose, and I know this court has done a number of resentencings for juvenile life without parole cases. That is not what this case is. This defendant pled guilty to second-degree murder and received parolable life. But since he was 18 and under People versus Stovall, People versus Poole, we've agreed that he is required to get a new sentence because parolable life is still a life sentence.
Correct.
So the pre-sentence investigation report incorrectly says that this court is bound by MCL 769.25, which is the statute that when we re-sentence a life without parole case for first-degree murder, binds the court to impose a minimum between 25 and 40 with a maximum of 60, which I know this court is familiar with. On this case, because he pled guilty to second-degree murder and assault with intent to murder and conspiracy to commit murder, there are actually sentencing guidelines. The sentencing guidelines at the time of his original sentencing are, I believe, correct. I believe Mr. Ambrose is correct, believes they are correct. And what we would be asking this court to use today to conduct this resentencing. So essentially, we're here because we agree he cannot receive a parolable life sentence because he was 18 on this case, but instead this court should impose a term of years sentence. And we'd ask the court to use the original sentencing guidelines, which you'd have to use anyways, but they are not attached to the updated PSI. They're on the, yes, we do. We have the original PSI, and the original sentencing guidelines were 180 to 360 months or 15 to 30 years. And so that's just when we're addressing the court, I think, and I'll let Mr. Ambrose speak, those are the sentencing guidelines that should apply to this case. If the court can just use, instead of asking to go redo this whole PSI and have him be adjourned again, I think Mr. Ambrose would agree he doesn't prefer that, but we can all acknowledge on the record that what should happen here is just a resentencing on the convictions, second-degree murder with the guidelines that were in place at the time.
So stipulated?
It is.
All right, and tell me I read the report, but what modifications, if any, do you want me to make to the body, perhaps I should strike pursuant to the enactment of MCL 769.25, he's eligible for resentencing, or?
Yes, Judge, look, that too, and even on the initial page, it will start there, the face, well, I think that I always still staple them the way that we used to staple them, where the cover page has the sentencing date of January 6th. Obviously, the date today is the 15th. The attorney is not Steve Cornish, it's Ron Ambrose. And then I calculated that he also needs to increase his jail credit to 9,190 days because of the change in the sentence date.
Sir, you agree?
Yes, sir.
All right, I'm changing that on the cover page and basic information sheet, just give me a moment. All right, and then I'm looking at instant offense, that needs to be changed as well. Changing the sentence date to today's date. So as to counts 5 and 6 on instant offense, I've changed this sentence date. And looks like then we've taken care of everything.
From the
Unless the dates are the jail credit dates are somewhere in the body, I'm just looking for that. Oh, and then would you like me to add, so under evaluation plan, it says that he was before the Honorable Judge Collette. Now, do we want to put, and now for resentencing in front of me, or leave that alone? It doesn't matter to me.
I would leave that to the court's discretion, Your Honor. I think it makes sense to know that it's before you for resentencing.
Okay, have you done that?
And then, Your Honor, you did mention it, and I don't know where we want to put it, either under evaluation and plan, our recommendation narrative, just that that statute referenced does not apply, and that we are using the sentencing guidelines from his original sentence. Because his original PSI is attached to this one, so it is part of the file, but maybe just to notate that in the record, I think would be appropriate.
I just added after I struck pursuant to the enactment, blah, 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 that line, I'm adding a sentence that says using original sentencing guidelines of 15 to 30 years, in parentheses, 180 months to 360 months is being used by stipulation of counsel. Is that all right?
That's all right from the people, Your Honor.
Yes, sure.
Okay.
And then, Your Honor, the people have no further corrections to the body. I think Mr. Ambrose has a few things he wants to take up with the court, and then we'll be prepared for allocution.
All right, thank you.
Yes, on page 1 of the body of the report under evaluation plan, it indicates that the defendant incurred a total of 31 misconducts. My client has brought with him his misconduct summary, and it should be 29.
Any objection?
No, Your Honor. I reviewed the document.
Thank you. I made the changes, are the dates correct between November 27, 98 and July 29, 2021?
That is correct.
Okay, thank you.
And within that same paragraph, it indicates that he has a smuggling charge. There's no misconduct for smuggling. So I'd ask that that be stricken.
By stipulation,
No objection, Your Honor.
it's struck. So I have probably a silly correction, but it says, and unauthorized occupation of a cell or room. I would like to put of a jail cell. When I initially read it, it's not, I mean, we use cell as cell phone, jail cell. I just want to be very clear that it's a jail cell.
No objection, Your Honor.
Anything else?
No, Your Honor, thank you.
All right. And you said there's no here?
No, Your Honor, I'll be speaking on their behalf.
Okay, have they been contacted or attempted?
Yes, Your Honor.
All right, you may proceed.
Thank you. In this case, Your Honor, we're here because back in the year 1998, this defendant planned the execution of 2 people who witnessed him assault somebody else, which was his plea in his other file that he received a sentence for assault with intent to do great bodily harm. So once those people witnessed him assault that person, he learned who those 2 people were and went with his co-defendants to their apartment. The defendant pressed the buzzer to the victim's apartment, and victim number 1, Kelly Ferris, opened the door. His co-defendant went inside, shot and killed Ramon Soto, whose 3-year-old son was lying on the bed next to him. The co-defendant then shot Kelly Ferris in the neck and shot and killed Deborah Miller by shooting her 3 times in the head while she laid on the couch. The co-defendant then went back to finish killing Kelly Ferris, but his gun jammed. So he unsuccessfully did not kill her, but he did shoot her, and so that was his assault with intent to murder conviction. And as a result, he pled guilty to 2nd-degree murder, and he was sentenced to life with parole, meaning he has been up for parole first after 15 years and then every 5 years since, and he has not yet been paroled. Because he was 18 at the time, and pursuant to People versus Stovall and Poole and the cases that have followed, he is to be resentenced to a term of years sentence under the law. So this is not the same, Your Honor, as those life without parole cases where somebody went to trial, they received automatic life without parole, and they have to be resentenced under the law. He negotiated a sentence and a plea, and he received second-degree murder. And so we're here because the courts have decided that that is an unconstitutional sentence to get parolable life. However, I do think it is important to note that this was a negotiated plea and that this was an outcome, a potential sentence he would receive as a result of a plea that he made. And on behalf of the victims, we have located the family of Ramon Soto, the family of Deborah Miller, and have attempted to reach the surviving victim, Kelly Ferris. Ramon's mother just passed away before we were able, right before this came up. So we were unable to inform her about this, but we have spoken to Ramon's brother and his son. That 3-year-old who was in the bed next to his father when his father was executed is now an adult man and has suffered trauma ever since this event. And we've spoken to Deborah Miller's mother and informed her of everything that's going on as well. And as this court knows, one of the worst calls we have to make as a prosecutor is to let them know that a sentence they thought was finished and complete from 1998 is now going to be reopened. That wound, that closure that they had received has been blown wide open. Something that they don't want to think about every day, that lived with them all the time, and the loss of this person that they loved is now back before them again. And so part of what I would like to do, Your Honor, is from the original sentencing on November 18th, 1998, these victims did speak. And so I'd like to read into the record the victim statements at that time, because I think it is important for this court to hear the pain from those victims at that time as well. So from November 18th, 1998, Mrs. Butler, Mary Butler, made this statement. Mary Butler, Debbie Miller's mother. I'm not going to say what I had written here because Mr. Zoulakis, who was defendant's trial counsel at the time, seems to have forgotten that Sean Brown went and got the gun. He left the apartment, he came back with the gun. So as far as I'm concerned, he's just as guilty as the rest of them. And for his sentencing, I think that to stay within the guidelines would be a gross miscarriage of justice. And Ramon Soto's mother, Sandra Soto, said, Ramon was taken from us through a senseless act of violence committed by Sean Brown and his co-conspirators. Not much has been said about Ramon throughout this trial, except that he was unfortunately at the wrong place at the wrong time. We would like Your Honor to know that Ramon has been a single parent who, with the help of his family, has been raising his son Devin since he was 5 months old. Ramon also had a daughter named Leanna. He was someone you could look to when you needed a friend or just a good laugh. He was so full of life, but now that life is gone, taken away from us because of these individuals and their own self-preserving reasons. We still ask ourselves why. Why did Ramon have to die? Why did they feel it was necessary to commit an act of murder? The only answer that seems to fit is that these individuals just don't care. They don't care who has to be hurt or killed to protect their own interests. That is why we are asking Your Honor to send a message to Sean Brown and others who have a total disregard for human life and impose on him the longest prison term possible. If that means exceeding so-called guidelines that are normally set in these types of crimes, then that is what we are asking Your Honor to do. We respectfully ask that you do what you can to make sure that this defendant is never again able to hurt another person as he has hurt Ramon, his children, and his family and friends. And Your Honor, Kelly Ferris, who was the surviving victim, we had reached out to her. She has an inpatient facility in Texas and is unable to be here. But I do want to read again her statement that was made at the sentencing. And it says, my name is Kelly Ferris, and I don't really have much to say to you because you disgust me. And you know, like the other day when you were being hauled off to jail and you blew me kisses through the cop car, well, see you later. And so, Your Honor, I think it's important to read those statements because as Mr. Soto's mother is deceased, she's not here to speak to the court. As Ms. Ferris is in Texas in an inpatient facility, she's unable to be here to speak to the court. And similarly, Deborah Miller's mother is not here today to speak, but the pain that they felt obviously at that time was enormous, and the loss that they felt and continues to affect this family. And at the original sentence, the prosecutor asked this court to exceed the guidelines and impose a sentence of 600 to 900 months, which was 50 to 75 years. And Judge Collette at the time imposed parolable life. And so we would say, considering the time this defendant has spent, I've read everything he's done since he's been in prison as well, but also the enormous benefit he received from his sentence now that we're back here, having it being deemed unconstitutional, we'd ask this court to recognize his youth. Of course, he was only 18 at the time, in addition to the snow factors, and sentence him within the sentencing guidelines. We're not asking for you to exceed them, but to the maximum under the minimum range, which is 360 months or 30 years. Thank you.
Thank you. Counsel?
Thank you, Your Honor. You know, I've been with Mr. Brown now for coming up 2 years. And, you know, every time that we speak, he always talks about his actions on that day and his remorse for it. And over the period of time that he's been within the MDOC, he's taken advantage of just about everything he could. And not only that, he has taken money out of his own resources and others to pay for services that he can improve himself. And he's done that. I've attached his accomplishments to our resentencing memorandum. And there's a vast amount of certificates that he has achieved. The sentencing guidelines in this case are at the bottom end, it's 180 months, and that's 15 years. But that still does not take into account his status as a youthful offender. And I think if you look at this in a common sense way, that could even be shifted downward because it doesn't take into account his youthful status. They don't have quote unquote sentencing guidelines just for youthful offenders. These are guidelines for adult offenders. So I would ask the court to sentence him at the bottom end of the guidelines because that would take into account his youthful status. I don't have anything else to add. I think Mr. Brown does have some comments that he would like to address.
All right, you may have a seat. Sir, just to remind you of the original counts that you pled to. Count 6, weapons, felony, firearms, punishable by 2 years, and that would be consecutive to and preceding any term. It looks like you've served the 730 days with that. And counsel, I wanted to ask you about that on the recommendation sheet. They did that a little weird. They wrote minus 730 for felony firearms, which doesn't, I don't know. I think I'd like to strike that because that is how they wrote it. It's weird because they end up with a total of 9,363 days, and that simply is incorrect. Is that right? You see where it is at the top there? So he gets total credit of 9190 on the remaining counts that I will read, but he gets the 730 on the 2 years, which is 2 years credit. And then what they did some weird math here. So where it says total days jail credit, it should be the 9190, shouldn't it?
Plus 182, Judge, for when he was held with no bond, I think. But yes, it's bizarre because he's not being resentenced on the felony firearm because that's a legal sentence. So I think you could say, agreed, that he was sentenced to that. He served 730 days. And I agree that on these sentences, the initial arrest was 182 and then not minus 730 days. I think initial sentence could just read 9,190, add those two together, and that's his total credit for these new counts.
Right, it's not 9,363. They messed that up. So I'm just going to put 730 days for felony firearms served in parentheses so that we know that was accounted, but it's 2190 days.
Yes.
Does that make sense to you?
It does.
All right, and then, sir, we have count 7, homicide, second degree, punishable by life. Count 8, homicide, murder, second degree, punishable by life. Count 9, assault with an intent to commit murder, punishable by life. Count 10, homicide, open murder, statutory short form, punishable by life. And you've been given the 9,190 days credit, and you recall all of that from your initial sentencing, correct? All right. Now, what would you like me to know?
There hasn't been a single day since May 17, 1998, that I haven't dealt with regret and a profound remorse for partaking in the murder of Ramon Soto, Deborah Miller, and the attempted murder of Kelly Ferris. I understand what I took from them, what I took for their families, all the pain that I put upon them. I know all the bad memories or the traumatizing memories that I put upon that community and on my family members also. I kind of wish they was here so I could like really ask for forgiveness. Don't know if I will ever receive it, but my actions from to the future, from now to the future, will definitely reflect who I am today, and that I'm not that person who committed those heinous crimes to Ramon Soto, Deborah Miller, and Kelly Ferris. I have plans on being a positive person in my community. I got different organizations that I'm in tune with. Mike Silk Guns Down the Right Away, Safe and Just Michigan. I got my family. I'm just deeply apologetic and just sorry for what I did and for what I took from everybody. And I understand it. I wish I could take that away. And I know I can't, but I wish I could. But through the actions of what I have going on for my future will definitely reflect that I am not that person who did the heinous crimes in 1998.
29 misconducts. Now, it is impressive in the last 4 or 5 years, maybe 4.5 years, you haven't had any, but 29?
29 tickets, but my last major misconduct is from 2016. That was a minor misconduct. The last major misconduct is from 2016. And 29 tickets, a lot of the tickets when I first came to prison, I didn't think I was going to get out. When I first came to prison, the average time for a second life was 43 years. So that's what I was looking at. So when I came to prison, that was the attitude that I had, and I carried it on into 2016. I just got tired of being a failure and doing everything that everybody expected me to do, or being under the influence of everybody else. And when I made that change, it was a total transformation. Like everything since 2016 has been on a positive path. Like I said, I call it a minor ticket. And that was for being in the day room, heating something up in the microwave when I wasn't supposed to be in the day room. I still strive to better myself every day. It used to be a hard struggle, but now it's not, because the criminal way of thinking is just totally over with. I just want to get back out and live for my family and do what's necessary for those around me, community, and myself.
On the day you committed those heinous crimes, a number of families were affected, and 2 people couldn't go home to their family. They couldn't pick up a phone and call. They had no visitation, no holidays, no time to raise their children, enjoy a movie, eat a meal. On that day, your family lost you. but they can show up and see you, they can write letters, they can call, they can give you Christmas gifts, they can enjoy a meal with you. I agree that the youthfulness of someone is often not considered. There's no youthful guidelines. And the legislative thinking on that is because, and I've heard enough arguments and worked over there for a decade when there has been criminal reform, but just so we're clear, while the science says that brain does not develop until you're 25, maybe 26, there's no youthful guidelines that are special to those young people because sadly, adults would maneuver them to commit their crimes. And that's how we ended up with juvenile waiver. And I worked over there when that was the case because so many people were using children to commit heinous offenses with no consequence. You'll be out in a year, nothing will happen. Go to juvie, nothing will happen. So while your words, counsel, are not lost on me, I do understand the legislative intent and the public policy behind it. But there is science about the brain, and judges do consider that when sentencing. The Snow factors are punishment of defendant, and sir, you spent, let me see, 25 plus years already
27 and a half almost.
because of the 2 years on
Yes,
the,
ma'am.
yes. And so, is that enough punishment? I don't know. It does look like you are on a strong road for rehabilitation. Deterrence of others, I hope people are watching this and realizing that your youthful indiscretions have a significant and severe consequence. And when you take the life of another, you lose a significant portion of yours. Protection of society, I think that society does not have to fear you because your record does show that although you went into jail, or I'm sorry, prison angry, and you did have a number of misconducts, in the last 4 or 5 years, there hasn't been a major or a minor one. And that does speak to me. But the sentence also has to be proportional and reasonable given the nature of the offense. And when I consider the victims and the loss and the trauma, I have to wonder what is proportional, sir. As much as I should give you the 30 to 60, ultimately, I think you ought to serve 30. But you have served the 2 years extra because of the other crime. So I'm going to sentence you on concurrently on counts 7, 8, 9, and 10 to 28 years to 60 years. So you still have some time, but it's not the 30 years. That's the best I'm going to do, sir. I'm sure that the victims and the prosecutor are not happy. But this is a compromise. So ultimately, you'll end up spending 30, but it's like forgiving the felony firearm. And I find that this is reasonable and proportional. It meets the snow factors and proportionality that I also have to consider. You have 42 days to appeal and to request appellate counsel. You'll have the credit for the 9,190 days.
190.
9190. Is there anything else I need to address?
Nothing from the people, Your Honor.
Do we have a question?
Well, he had some,
I went to the parole board in March and got approved for a public hearing. I had a public hearing October 7th. I was supposed to have it home by now by Christmas, but MDOC messed up on my address. The address is correct in the PER, but they had me paroled to Ingham County, but I'm actually going to Clinton County.
Okay, so you deal with them and they'll do what they want with this. So I don't know, I don't run the Michigan Department of Corrections. They may stand by that, they may not. They're gonna look at this. This is far less than what you had, so they may say you're good to go. I don't know. We don't run the, once I make the sentence, you become over their jurisdiction. So you've got to talk with them. You acknowledge receiving your appellate rights?
this,
Counsel?
the person that committed the actual fire shot. Oh. I just don't want that situation to serve more.
I made my decision. I mean, sir, I know the recommendation was for 25 years. They didn't get the right statute. I know there was a co-defendant. Each case stands on their own. I don't know, is that co-defendant coming in front of me? I don't know what I did or didn't do or what he's doing. So I've already ruled this. I've shaved 2 years off. My initial, you can see my notes. If you want to, you're gonna take them to, take my notes there. I originally put 30 years. But after hearing you speak, I shaved off 2 years. I don't have to do that. And I'm not gonna give you more time. I made a ruling. I've made my reasons why. And so you'll be out before you know it, I'm sure. I'm sure it's a long time, but sir, we got a couple people in the graveyard who can never be risen. At least to us, they're with God. The next judge you face, I hope, is the higher court in heaven, and you explain it to him. Meanwhile, I've made my decision. Anything else for the record?
No, Your Honor.
No, 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 thank you.
Do you acknowledge your appellate rights?
Yes, Your Honor.
Thank you. That's all for the record.
stay 2,000 feet away at all times from her body. Because, like I said, I think that was simply, they forgot to write that down, because that's usually in every one of these cases. But that's why technically it's not a violation, because that wasn't a condition of his bond at the time, regardless whether it should have been or not.
Thank you for responding to that.
Go ahead.
Thank you. We did confirm that the order did not prohibit him from both going to the same sporting events for the family. The kids are adjusting to this, and they have a weird, in my opinion, weird parenting time agreement with, they'll have on and off, but the siblings will see each other less. He was not standing directly next to her. He was also present. He was also present with his parents to make sure that there was absolutely no issues. She's tried to reach out to him through multiple avenues, and he has not communicated with her except with regards to the kids, because I told him that's the only way you guys should be talking about anything at all. So we do appreciate the court signing the order to remove that. He's going to continue to not have any contact with her except with regards to coordinating parenting time, and only through in writing as declared allowed by the court. Thank you. I apologize, Ron. I would ask the court not to also say that he can't go to their sports events and things like that, just because there's constantly going to be, I think for a while, hopefully it ends within the next few years, contentious child custody and parenting time proceedings. So I would just ask that he not be ordered to not support his kids in their athletics, and there haven't been any issues in 7 months. Thank you.
Who's exchanging the children?
Kids are usually with him, and he's taking them to the sports, and then she'll show them. If that answers the question.
No, that wasn't the question.
I apologize, Your Honor.
The question is, how is parenting time being exchanged through a third party?
So it's either his parents will coordinate that, or he'll meet with her dad to exchange.
Okay, so they're not meeting, they're not exchanging them together.
Correct, Your Honor. They're not face to face for any exchanges and things like that.
Sir, when you're at these school functions, how many feet are you approximately away from her?
I usually try to sit on the other side of the bleachers, if not on the opposing teams.
Give me an approximate. 20 feet, 30 feet, 10 feet, I don't know.
50 to 100. That's if she shows up.
Great, here's what we're doing. I'm removing the tether. Sir, she doesn't exist in your world. I don't care if she dances naked outside your bedroom window. You call 911 and have her removed. You do not talk to her, you don't let her in the house, nothing. Okay, no communication by Hallmark cards, smoke signal, carrier pigeon, third parties except as allowed by the family court for the benefit of the children. You will continue to exchange the children through grandparents or a third party that is agreed to through the friend of the court. Bond is amended to reflect that you will abide by all family court orders, and you shall remain 1,000 feet from the victim. You can, however, attend school functions and remain 40 feet away from the victim. Now, that means if she addresses you or whatever, you just turn your back. If it becomes a problem, you get a personal protection order against her. There's lots of ways to handle this. What you don't do is violate my order, because you'll end up in jail and miss the school functions. Yes,
Can I ask a question?
yes.
His question was just with regards to she'll drive by his house in order to facilitate. I told him this doesn't affect that.
I don't have jurisdiction over her, only you. Now, if that's a problem, if she's honking in the middle of the night at your house, if she's throwing eggs at you or whatever, that's a problem. And that we address by, first of all, alerting the prosecutor's office, but second, going downstairs to the personal protection office and getting that. Additionally, advising your family court judge, because that's not in the best interest of your case or the children. So, you know, there's lots of ways to handle it and document it.
The only thing I did want to bring up, Your Honor, is we did previously enter a stip in order to allow them to communicate through the app in
That's
order.
fine.
Okay, you just said there was no.
Yeah, well, through the family court orders, if that's allowed, but otherwise no communication. And that communication is only about the children.
Correct.
Okay, so about the children is fine, but if you communicate about anything else, then that's not fine.
Thank you, Your Honor. I just wanted to clarify that.
That's why I have all family court orders and remain 1,000 feet and can attend school functions. So that communication, I can say and communicate about the children only through the family court app. All right, so this is a combination order removing tether and bond modification.
Thank you, Your Honor.
That's all for this record.
We're trying. Oh, so there you go. There's obviously.
This is docket 20-915 FH. People of the state of Michigan versus Arthur LeClaire.
Yeah, sorry, everybody else knows.
Sorry, I just called the case. Counsel, your appearances for the record.
Good morning, Nicole Matthews on behalf of the people. Also standing beside me is Agent Castillo from the Adult Probation Department.
Assistant Public Defender John Lee on behalf of Arthur Clarence Lee Clare, who is in the courtroom and standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth? And
Yes, ma'am.
Thank you. Put your hand down. Sir, do you still live on South Pennsylvania?
Yes, ma'am.
All right. Sir, you pled guilty to child sexually abusive material, aggravated possession, punishable by 10 years. You were placed on probation. And I now have a request for a bench warrant. And it states on or about May 28th, 2025, defendant tested positive for cocaine and methamphetamine. Is this the violation we're dealing with?
Yes.
Is that because he was not to be found or what? Why is this so old?
Your Honor, I believe he was on absconder status until he was picked up on this bench warrant. So
I
for 6
see.
months, we didn't know where he was at.
Okay. And count 2, on or about May 28th, 2025, defendant admitted to consuming alcohol. Count 3, on or about May 28th, 2025, defendant failed to comply with his internet use agreement. And then on or about May 28th, 2025, defendant failed to register an internet identifier with Sora. And finally, we're going to have to add in one that's count 5. Defendant failed to appear to probation since when?
Yes. It's gonna be, on or about June 4th, 2025.
Count 5, defendant failed to appear to probation since on or about June 4th, 2025. Any objection to adding that from either counsel?
Not enough people.
No objection, Your Honor.
Counsel, you've talked about these with your client?
I'm sorry.
You've spoken about these allegations with your client?
I have spoke to him about the allegations. We have not yet received any paperwork or discovery. However, I have spoke with the probation officer.
You should have received a copy. Do you want a copy? Well, when that happens and you speak to him, come up and get my file.
Okay.
We'll make you a copy now.
Okay.
Are you waiving further arraignment?
Are you
Further arraignment of the?
Yes, yes, ma'am.
All right, and sir, have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
I'm just getting over a cold.
All right, are you well enough to proceed today?
Yes, ma'am.
All right, and you've talked with your attorney. We're gonna allow you some more
Yes.
time, I guess. I can take another matter while you talk to him, or how do you want to proceed, counsel?
My understanding is that probation wants to make a recommendation for revocation. However, they need to prepare a report to do so. So in talking with the prosecutor, we decided to just set up for a hearing.
Okay, well, we're gonna get you both copies, and then when are we going to, do we have a date, or would you like me to give you a date?
Probation needs at least 14 days to prepare the probation violation.
Okay, let me give you a date. Counsel, if you would pull up your schedule. So on behalf of probation, would you like January 28th or February 4th?
If we could do either or works, Your Honor, let's do February 4th.
All right, does that meet with your schedule, counsel?
Yes, that would be fine, Your Honor. I do have a couple things early in the morning, but after that, we're free.
All right, then February 4th at 11:30. Anything further?
Your Honor, at this time, I would ask that his bond be revoked and he be remanded to Ingham County Jail pending that hearing.
Counsel?
Your Honor, Mr. Leclerc would appreciate the opportunity to at least be able to post a bond if the court was inclined to set one for him. He's not a flight risk.
No,
participate.
Well, he's not a flight risk, but I haven't seen him for 6 months. So what's the story there? I mean, if he cared, if you cared about this.
They never contacted me, ma'am. They knew where I lived. They raised my house. They knew everything. They knew my phone numbers and everything.
Sir, you were supposed to report to probation at least monthly. You're supposed to follow them. They don't chase you.
No, they said I was done until further notice. And there was
Is
no
that
further
true?
notice.
That is not true, Your Honor. They had went to his house on 528, like he had mentioned, and that's where he had these additional violations that were on there, Honor, as far as testing positive for methamphetamines, I think that he was drinking, and then it was reported, give him a next report day of June 3rd, which he did not report, and then failed to report anytime thereafter.
Bond is revoked. I'll see you then.
Yep, they're lying.
Is that it?
It's all for the record.
Could be here. Could be well. So the people on the record is people versus Timothy Pitcher. Mr. Pitcher is not here. It's my understanding the writ was done at the last hearing.
All right, this is document 25-241 FH People State of Michigan versus Timothy Lee Pitcher III. Counsel, your appearance for the record.
Thank you, Your Honor. I'm sorry.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Aaron Schroeder. On behalf of Mr. Pitcher, originally was second chair on this file. I am where I am at the moment.
Your first chair.
I'm now first chair, I
But
guess.
I don't care what happened. You were second chair. First chair is with God, so now you're with me. Okay?
I understand.
Okay.
Mr. Silverthorne was supposed to be taking.
Well,
I understand.
don't care.
For MIDC purposes, Your Honor, Jacob Sarts the fourth, second chair, supervising senior attorney for the purposes of the file.
Great. We're
Thank
gonna be
you.
seeing a lot of this. There's just no excuse for delay. I don't care who's sick or who's got taken. My docket is getting behind because of all of this. We need to just partner together. And you're all very smart attorneys who are in front of me a lot. You can handle this case. I know you can. You're always prepared. So we're good. So the problem that we have in this case, however, this was set for a plea January 15th at 10:30. The court has waited now an hour. Well, it's 11:25, so 55 minutes. It does not appear that Mr. Pitcher is here for his plea.
Your Honor, we had initially talked about doing this plea back then, and because there's so many issues with Polycom with MDOC, we said, nope, we need this to be in person, so that way the defense can have a real good, non-glitching conversation with their client in order to enact this plea. We did that writ that day.
Okay,
It seems like he's been moved facilities since then, which I am graciously assuming is the reason he's not here. So because of that, we need to adjourn so we can get him here, so we can do another writ to get him here. I want to do it as soon as humanly possible. I know MDOC needs 2 weeks, so I'd like to set this out for 2 weeks.
Great.
We're done today.
we can do it February 4th. However, I am going to begin, I've said this before, I want to show cause MDOC. It doesn't matter what building he's in. They are under obligation, same as we are, to keep track of people in the jail. They have facilities all over and they should talk to each other. So I would like a show cause to the warden of both facilities if we need to.
What time on February 4th?
Oh, let's make it 10 o'clock,
10 o'clock.
along with the show cause for the wardens of both facilities. I am unclear how this continues to happen, and we need to send a message. They're wasting council time, my time, your time, the people's money, and they seem to think that they're above our orders, and yet they maintain our people. It's not fair.
Again, I have no idea what
Well, if
happened.
you find out there's a different story and I should not issue the show cause, great. You
Yeah,
let
if I
me
find
know.
out they didn't get it, or there was some issue with it, I will let you know, but as far as I know, yeah, we did,
I wouldn't know for sure. Don't think.
okay. We do not know the reason.
You
I know
figure it
that
out.
we
If you
asked
find
for
out it was valid, I want to show cause to both wardens, and let's send a message here and now. This happens What, once a month? I'm done. I'm really done. Thank you. Anything else for the record? Just meets with your schedule?
Yes, Your Honor, we'll make it work.
Yes, yeah.
Thank you.
Thank you.
Thank you, Your Honor.
What did they say, February 4th at 10, right?
February 4th,
February 4th at 10, yeah.
Brian, I haven't read.
Yeah, absolutely.
Okay. Elamine,
Yes, Your Honor.
where is he?
He may or may not be here either. He's in DOC.
Correct.
They don't have him, and he's not on Zoom.
I'm willing to waive his appearance to try to get this moving, Your Honor.
Okay, I mean, I think we can do that if this is in his favor. We don't know, or if it doesn't change.
Nikki, I'll go grab that.
I haven't sent it to you yet. Well, it's coming.
Okay.
I just have to get a PDF.
All right, this is docket 23509 FC, People of the State of Michigan versus Isaac Noble L. Amin. Counsel, your appearances?
Jeremy Skortenbor for the prosecution.
Good morning, Your Honor. Christopher Whitman on behalf of Mr. El-Amin. Mr. El-Amin is currently in the Michigan Department of Corrections. This is an appeal matter. My understanding is he can be transported or be available via video. If that is not the case, I would waive his appearance. For the purpose of this, he will receive the full transcript of proceedings in this matter as well. Just because this has been substantially delayed, I'm not trying to get yelled at by the Court of Appeals for not moving fast enough, Your Honor.
So we will provide a transcript if you're waiving his appearance, but my question, as in the last case, did MDOC receive the writ and have they not complied? Because we need to do a follow-up show cause. This is sadly a pattern of theirs. Did they receive a writ?
I would not know, Your Honor. However, just as a matter of law, his appearance is not required here.
Okay, all right. Well, if they received a writ though and chose to not comply, I would like to know about that. We'll show cause. But if his appearance is not required as a matter of law and if counsel has waived it, I'm sure his client has said he wanted to be here, but nonetheless, we've made a record and we're going to proceed. So, Mr. Whitman, in regard to the motion for new trial and or resentencing.
Yes, Your Honor. Would you like me to start with one particular motion or the other?
It doesn't really matter to me. I suppose maybe would the resentencing, if I agree to that, get rid of the motion for new trial?
I think it would be the other way around, Your Honor.
Then let's do the new trial.
Okay, thank you, Your Honor. So we are on the motion for new trial. We are requesting an evidentiary Ginther hearing. If the court does not grant such, obviously this could come before the court again on the remand order. There are two issues on the motion for retrial. First is failure to object by counsel to improper jury selection process. Second issue is failure to introduce a crucial piece of evidence to support a defense that was not basically fully pursued in the circuit court. It was asked about briefly by counsel, but not followed up on or provided any kind of evidence with regards to that.
So explain to me this whole jury selection objection.
Sure. The jury selection process is spelled out explicitly in the court rules,
Yes.
and it was not followed by the court. I know the court can make record if the court so chooses, with regards to that. What it was is the court did not swear the jurors in initially and instead just asked, does anyone, this is a domestic violence case essentially, can anyone not be fair and impartial? The individuals then would raise their hand. I did, obviously the transcript doesn't show it, but you know the court knows jury selection and it's who can get out of it. They said basically their juror number, they were not required to give any reasons for it or anything like that, which is not in compliance with the court rules, which has specific for cause objections, and defense counsel did not object to those things in a timely manner. 22 people were struck without stated reason. I believe one person did state a reason without being asked. But basically, the concern from the defense on this is it allows the jury to self-select out, which, you know, no one wants jury duty. I think other than maybe the people in this room possibly. And by saying this is a highly emotional case, such as a domestic violence, where we all kind of carry, I think, predilections or our own personal opinions in, we allowed people who didn't want to be on that jury to self-select out, which leaves individuals who, in theory, do actually want to be on the jury because they have a personal belief or bias potentially in it.
Can you show any prejudice? And obviously, I don't have the transcript in front of me, but when we do those, people are very emotional. When they hear the charges, they start crying. There's neither counsel wants them, and I always advise counsel they may object if they wish. No one objected, and there were a few, and I don't remember, but I always say, can you be fair and impartial? This is going to bother you? Yes, 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 yes. If somebody doesn't want to be on the jury and that's what they want to do, they want out anyway. You don't want that jury. I've never seen any counsel worth their salt want to keep somebody who says, yeah, it's going to bother me, I'm out, I got whatever excuse they make. So I'm unclear as to how there is any prejudice, because when we got to, and I always on these cases order almost twice the jurors that we need. And when we got to those sworn jurors, we had those jurors who were viable, wanted to be there, were engaged, and still we struck more and still had plenty of jurors left over. So what's the prejudice here?
Sure, Your Honor, and I think that some of the prejudice can come out through a actual evidentiary hearing, which is what we're requesting.
Well, before we get there, tell me what it is.
Yes, Your Honor. Respectfully, I keep jurors on who don't want to be on juries. Because no one wants jury duty, or else we would have no juries to a certain extent. The only individuals who would want to be on a jury are the individuals who feel like they're going to prove something through it.
Have you kept jurors who have been affected by domestic violence on a domestic violence case? Because I don't think you do.
Not for domestic violence, Your Honor. I've done it with CSCs, which I think is comparable as far as the emotionality aspect of it, Your Honor. Now, what I will say is that if we had factual details on these 22 people that they were actually affected by it, and it wasn't just because the court is overseeing selection of hundreds of juries, if not thousands. And at this point, when it comes down to it, what happens is one juror is excused, and then all of a sudden everyone else has the same exact problem because they want to go home.
Well, that's not the way this happened. Several hands went up and tears were coming out. So maybe what I should do, certainly I will swear the 200 I bring in from now on. And I've been doing that. However, I like to just clean house and get to those because I order almost, like I said, double of what we needed because of this exact issue. And I can say, let the record reflect, this juror is crying, this juror is visibly shaken, this juror can barely walk out of the courtroom because it is triggering. And the court does not want to trigger people in our community, especially when I have ample jurors. Now it's a different case if I have 40 jurors and we got a DV and I know we're going to go down to 1 or 2 remaining, or I need to call a new batch the next day. But I don't see any prejudice here. But okay, I mean, we can have a hearing.
Okay.
Do you want to waste my time? But I'm going to defer to the prosecutor and see what they have to say about this. Is there anything else you want me to know in regard to this motion, or is it just based on jury selection?
A lot of it is responding to the plaintiff's points, but they're asking for no evidentiary hearing, so I think much of that argument could be. The only note I do want to make with regards to if the court's going to order the evidentiary hearing, which is my understanding.
Well, not yet. I want to hear from the other side.
Sure.
I mean, I just want to be clear, that's what you're asking for, and I suppose we can waste time doing that, but I suppose we would also need to call those 20 or 30 released jurors and ask them, which would traumatize them.
Correct, and it would involve calling them back in. We can't actually call the actual jury in to see if they wanted to be there, just because of the rules of evidence, Your Honor. So the proposal would be trial counsel about whether it was strategic not to object to this process, because this is still framed.
Have you talked to trial counsel?
I have not, Your Honor.
Well, why not?
I will,
Obviously, it's strategic.
I will clarify, I talked to him. I have not raised if it was strategic or not, because I think my representations in the court about his strategic or not, I don't believe was intentional. But I want him to actually answer for that. And then I would propose the 22 who were excused, because we can't question the jurors who are actually on the jury about their motivations and things like that pursuant to the court rules. So I would love to do that, but I don't think we're allowed to.
Thank you. On behalf of the people.
Absolutely not, Your Honor. In the first place, the defendant does not get an evidentiary hearing by merely saying, well, I'll develop it at that time. If he wants to show things like that, he'd better have affidavits. In fact, the court rule MCR's 2.611 mandates an affidavit for facts outside the record on a motion for a new trial. And he hasn't come up with anything like that. Now, deficient performance, prejudice. First, deficient performance. Defendant has to prove that every reasonable lawyer would have done differently. Now, US Supreme Court, that is what the standard is. He hasn't shown that. Secondly, prejudice. Well, he doesn't even come close on that. He doesn't even try to show prejudice on that. There is one case that sort of deals with this, where the judge didn't preliminarily swear in the jury ahead of time at all. Your Honor did at one point, but at all. And the Court of Appeal said, defendant hasn't shown prejudice. It's the young case, albeit unpublished, but it's cited page 3 in my answer. So categorically, no evidentiary hearing. I am asking that you deny the motion.
Thank you. Response?
Thank you, Your Honor. I'm gonna have to respond in more full details. Affidavit is not required. The court rules are pretty clear that the criminal rules supersede the civil rules if there is something in conflict, and that is in fact what is in this case. There is a court rule specifically with regards to a new trial. It has nothing to do with requiring an affidavit. It even references an appellate rule, which also has nothing to do with an affidavit. An affidavit is only required if the evidence is not in the record. This is part of my whole second argument with regards to the text messages. But when it comes down to it, the criminal rules explicitly say that the civil rules do not apply if there's a conflicting rule. There is a conflicting rule. Furthermore, even if the civil rule did apply, the text message in this case is on the record. The unpublished case that he cites to is not directly on point with regards to this. There was nothing with regards to the jury selection that was unusual or strange. In this case, respectfully, we're taking the position that the court did not follow the court rule as far as establishing a reason for cause for these 22 people prior to being excluded. That is.
I did give a reason for cause. If they can't be fair and impartial, they'll be affected by this, if they will be triggered. They cannot sit as a juror because they're not going to listen to it. So I did give a reason. I gave both counsel an opportunity to object, and no one did.
And Your Honor, if I can clarify, I'm saying the court rule requires that they be asked questions to elicit the reason why they cannot be fair and impartial, not just raise your hand and say, I can't be fair and impartial.
So let's talk about harmless error. Would this change the outcome of the case?
So this is subject to the Kane-Kareem's test, Your Honor. It's different than prejudice with other things. So the first 3 prongs are met even in the Young case that's unpublished. The fourth prong is whether it resulted in an actually innocent person being convicted, which I don't know how you prove that without being able to get relief otherwise, because, you know, Mr. Alameen maintains his innocence. And obviously the jury convicted him. You know, I don't know how that meant, but the other aspect of it is if it seriously affects the fairness of the proceedings or the public perception of the fairness of the proceedings. And that is the one that I think that is in fact met here with regards to it. Because we have individuals who are able to self-select off a jury is the defense's argument, leaving individuals who do want to be in that process. Like, for instance, I know the court would never allow, if we had a domestic violence case, to only bring in jurors who had a personal feeling about domestic violence and say, you're going to be our jury, you're going to be fair and impartial here. And I think that by allowing people to self-excuse them, we are leaving the people who do in fact want to be there. And it's especially problematic when the jury is not actually sworn to tell the truth, when they're not having their civic duty and, you know, penalty of perjury and all that invoked. I think that's especially concerning with regards to it. So I think that the fourth prong of the Kane-Kareens test is what we are in fact arguing about. And I think given the weirdness of the two circumstances, the jury not being sworn and not being reasons for being excused, I think does necessitate this court taking what's called a fact-intensive and case-specific inquiry.
Did you pull the transcript?
Of the voir dire?
Yeah.
Yes, Your Honor. We have all the transcripts for
Okay.
everything.
Do you have them here?
I have it on my computer, Your Honor. I try to go all digital, but they are in the court file.
So, okay.
And I apologize.
And did you look at how many jurors were pulled?
No, Your Honor, I just have the actual transcript of what happens, and I don't have the identity of those 22 individuals. The court, as per normal practice for the court, used only numbers rather than names as well. And I don't, no offense, I don't want to upset the court by trying to invade the privacy of these individuals, unless the court's going.
And I don't know why I don't have the full file, but I do maintain all of that. Nonetheless, your motion is denied. You can't show prejudice. I specifically for this reason, order more jurors than brother and sister counsel down the hall. The attorneys in this community know that. I probably ordered over 100 jurors. I don't know how many actually showed up, but for the reason that people who don't want to be there, people who were assaulted, whatever, they can't sit through it. Those people who don't want to be there have a dangerous potential of just following the crowd and not honestly debating anything, not honestly listening to it, falling ill during the trial, etc. Additionally, those people who have been touched by domestic violence, which based on the numbers of domestic violence is probably half our community, they ought to not sit there because they're going to take, and I've asked this repeatedly, their experience and pull it into this case. I didn't swear, okay, I swore the body, and there was a body left, as I recall in this case, of all nationalities, colors. The veneer was mixed, and the evidence in this case was clear. Even if we pull a new jury, the case here was very, very clear in terms of the evidence, and we're wasting resources and time. Well, I swear everybody, sure, but neither counsel objected, and we talked about this ahead of time, as I recall. We did pull 120 jurors, which is almost unheard of. And I did that because of domestic violence, felonious assault, multiple counts of domestic violence, felony firearm, unlawful imprisonment, a couple of counts of that, assault with intent to commit great bodily harm less than murder. And there were also later on questions about if there were 12 counts, how many of you think you must have done something? Multiple hands went up. So for multiple reasons, 120 jurors. That is not the usual procedure on cases. We usually get 80 maybe. And I went well over and above the number I should have called. And I'm constantly fighting with the jury clerk and administration about how much cost. But to have the best, cleanest jury trial, I overdo it, and I did that here. So I don't see any reason to do this. You may appeal me, everything is preserved, but I'm not giving you a new trial based on this.
Thank you, Your Honor. I think the court has made a quite thorough record with regards to the court's decision-making. Fun fact, we pulled 200 for a stupid misdemeanor last week
Well, that's
in a
just-
rural county.
Yeah.
It was a lot of mitigating issues that kind of caused us to use half of them at least. Your Honor, there was the second part of the motion for new trial, which is the failure to introduce the text messages. May I proceed to that argument?
You may.
Thank you. At trial, defense counsel essentially raised a procedural objection to convicting Mr. Aquilina as charged. Basically, he committed domestic violence, but it was overcharged. He should be convicted of something lesser. The text messages showed a second defense in the case, which is that the complainant was exaggerating or making up the allegations for her for a financial gain. I'm not saying, and I'm not required to prove that he would have been successful on this, but these are text messages that did exist. Trial counsel hinted at it, asked a couple of questions, but did not actually confront her with the text messages themselves. Those are attached, I believe, as Exhibit A to the motion itself. It is unknown if that was strategic between possible defenses, or if he forgot it or couldn't find it during the midst of trial, or he'll claim that he did never receive it. We would ask for an evidentiary hearing to determine if that was strategy or an error, and then we would be arguing about prejudice if it was in fact error. Plaintiff alternatively argues two kind of different things in response to this argument. The first is the jury was already presented with it through those questions, and the second is that if presented with it, the verdict would have been the same. So trial counsel did in fact briefly ask her about whether she thought he owed her money or owed her something, and the complainant claimed the money she was demanding was for the property he broke and for medical bills. But that's not what the text message exchange says. The exchange had a very different tone. There's no mention at all of paying her back for property he broke or medical bills. And the exact exchange, I do think merits reading for the record. Those are attached, as I said. You really a joke then? You need to be sued.
Say that again.
I apologize. You really a joke then? You need to be sued then. Making that, excuse my language, Your Honor, shit so clear to me when I try to give you a chance. I'm giving you so many opportunities for me not to take this to court. I don't understand why you would rather me take it to court than settle it yourself. Make sure you show your parents how hard I tried to settle it with you before taking it there. Give me my money. Why is that so hard? I gave you months. You have no intentions of paying me at all. All right, I'll just call the care program then. Everybody been begging me to take this shit legal. I'm the only one who's been wanting to give you the chance to fix it outside of that. I'm too nice. Yes, now I'm on hold.
Yes, now what?
Yes, now I am on hold. There's no mention of paying her back for medical bills or property. Counsel could have had a field day with that exchange and argued it sounded like an intentional months-long shakedown or something else to the police. Give me my money is not
What's the
something.
date of that? I mean, were the charges already filed?
I do not believe they were already filed, Your Honor, but I have to double check the timeline. That was when she called the care program. It started the whole police investigation and things like that, which also contradicts kind of what her story was as far as when she reported and why at trial.
Does that change any of the evidence?
It,
I mean,
one,
there was a lot of testimony and evidence in this case.
correct, she maintained the evidence for years and things like that. I think that it could absolutely lead to additional reasonable doubt when it contradicts what she said as far as where the reporting goes. I think it is also not truthful to say that she's asking for restitution and medical bills, and I'll get to that in a moment, but she supposedly gave him an amount and said, you need to pay me my money. At trial, she could not recall it. In the PSIR, there was no statement with regards to the amount of money she supposedly was owed. The court left restitution open for a period of time. We still haven't gotten any restitution
And I'm
requests.
sure it's closed by now, so isn't that moot? Is not closed?
I thought Your Honor kept it open for 3 years. That's what I
Correct.
was told.
Okay.
Yes.
In fact, I'd be asking for, I was planning at the end, but I might as well now, asking for a date to set the restitution hearing.
I would just ask for some kind of even allegation or proof, because I'm gonna have to coordinate with the client here.
Oh, yes, I have receipts.
Yes.
Well, how much time do you need for the restitution hearing?
Oh, I don't really know. I know that the evidentiary rules don't apply. So I would say, I'm just guessing half a day.
Would the court like me to proceed or hold off for that?
Well, would you please get me a half day from Nicole for an evidentiary hearing?
Yep.
And in regard to restitution?
Okay.
And what's the rest?
The rest of the argument,
Yeah.
okay. So December 8th, 2022 was that text message where he'd supposedly been given an amount of restitution. As of today, we still have nothing on that.
Well, we're gonna set that for hearing, so you're gonna get it and we're gonna figure that out. So
Sure.
that's done.
Okay.
What else do you want me to know?
If trial counsel had confronted her with this text message back then, he could have potentially raised reasonable doubt.
You gotta slow it down.
Sorry.
My fingers are frozen solid.
Yeah, mine too, actually. If trial counsel had confronted with this text message back then, he could have potentially raised reasonable doubt related to her motivations for bringing the case and when she didn't get her money. As plaintiff acknowledges, we don't have to show that there's even a preponderance of the evidence that a different result would have been likely in this case. Plaintiff's second argument says that basically he was convicted in 2.5 hours, so the jury clearly didn't have a problem with it. I will point out he was not convicted as charged. He was convicted of a lesser crime. A more reasonable doubt with regards to exaggeration is possible that it could have also led to lesser convictions and things like that in the case, or not being convicted as he was charged. And that's without the strongest piece of this evidence with regards to the financial motive being presented. With regards to the affidavit, I briefly addressed it. With regards to 2.611 does not apply. Does not apply in criminal cases. 6.001D says the provisions of the rules of civil procedure apply to cases governed by this chapter, except paragraph 3, when a statute or court rule provides a like or different procedure. 6001E, the rules in this chapter supersede all prior court rules in this chapter and any statutory procedure pertaining to an inconsistent.
Statutory proceeding.
Sorry, statutory procedure pertaining to and inconsistent with a procedure provided by a rule in this chapter. So if there's a different procedure, 6.11D does not apply. There is in fact a different procedure pursuant to 6.431 and references 7.208. Furthermore, the evidence is on the record. An affidavit isn't necessary that this is the text message that would be elicited at the evidentiary hearing with regards to that. That is all I had. So we would ask this court to grant the evidentiary hearing in this matter with regards to that. Thank you.
Response.
Well, yeah, okay, defendant's claiming ineffective assistance that requires two things, deficient performance and a reasonable probability of an acquittal. However, the US Supreme Court itself has defined that phrase. Now, for the deficient performance, well, in the first place, counsel did ask, did there come a time toward the end of that relationship when you thought he either owed you money or owed you something? And the answer, the victim answered, yes. I wanted him to pay me for all my property that he had broken and for my medical bills. So it did come out somewhat. Now, for deficient performance, defendant is, well, yeah, kind of right that he doesn't necessarily have to show by a preponderance, but the US Supreme Court itself has said the difference between Strickland standard, reasonable probability of an acquittal, and a more probable than not standard is slight. It matters only in the rarest case. The defendant is essentially asking you to ignore the US Supreme Court, the court that established the standard which Michigan has adopted. Michigan says in Pickens, 1994, says, oh yeah, we adopt a Strickland standard. And there it is. And all the defendant says right now is, well, he could have potentially raised. He has to show substantial prejudice. Given that it already came out, that her admission, that doesn't show it. And besides, we have absolutely no offer of proof that counsel knew it. Now, defendant can say all he wants about 2.611 not applying. Well, he's wrong because there is no conflict. However, last July, the Michigan Court of Appeals, People versus Wade, without such an offer of proof, defendant cannot establish the factual predicate of his ineffective assistance claim. Yeah, there it is. Hasn't presented the offer of proof. And even assuming counsel messed up, given what he brought in, given the evidence in the case, can't show the reasonable probability of acquittal as the US Supreme Court itself has defined that term. I ask the court to deny this motion without an evidentiary hearing.
Response?
Thank you, Your Honor. Plaintiff is arguing, yeah, he established it somewhat. The text messages are very different from the trial testimony. I don't think any reasonable attorney is going to look at the text message and say, yeah, that's what she testified to. So it is very different. The text messages in her words are very different than what she testified to. We are asking the court to follow the Supreme Court precedent. We're not asking for the court to disregard it. We're asking the court to apply the standard from the US Supreme Court, which is a less than preponderance standard. The plaintiff's been trying to make that a higher standard than it is and say, well, it's close enough to a preponderance. No, the standard is less than preponderance of the evidence. And finally, the prosecution is trying to say, well, we don't need an evidentiary hearing because otherwise he'll have the offer of proof that I'm saying that he doesn't have. We have the text messages to show that this is not a fishing expedition. This is not a, oh, well, I think I told him about this, which would itself be enough to get an evidentiary hearing in most cases. But what we have is the actual text messages showing it. They are dated. We know that they exist. We know that they were provided, and we will have a full, complete proof once trial counsel is able to say, yes, I received them, or no, I didn't receive them, and here's why I didn't present them. So I think that that would address any of the plaintiff's arguments. However, they're trying to use it aggressively, like don't give them an evidentiary hearing so that they can actually have this decided on the merits. We're asking the court to decide it on the merits. Thank you.
I'm adopting as my own statement of the prosecutor and denying.
Thank you.
I also have a date for the restitution hearing. I have two alternates. I have March 24th, 2026 at 9 a.m. or March 26th, 2026 at 1 o'clock.
Either is fine with me, Your Honor.
Give me one moment, Your Honor. My calendar's loading that week.
What was the time for the second one?
1 o'clock, March 26th at 1.
Both are open on my calendar, Your Honor.
Well, let's do it earlier than later, March 24th at 9 a.m.
And Your Honor, I'm assuming I'm going to receive this supposed evidence at some point.
Oh, yes.
Well, if you don't, you both can get hold of me and we'll fight that one out too. Is there anything else I need to address?
Not on the motion for new trial, Your Honor. We still have a motion for resentencing.
Yeah, let's proceed.
Make sure the Rick gets stopped for that.
Yes, let's please make sure he gets rated for that. All right, there are 5 different variables that were brought up in the motion to correct invalid sentence / motion for resentencing. I'm not going to restate all of my arguments. I'm mostly going to focus on responding to what the plaintiff says. Most of them, they basically say, well, this was waived, so that this court should never address it. Waiver is the intentional relinquishment or abandonment of a known right. That's People v. Koreans. To waive a known right, a party must clearly express satisfaction with the trial court's decision. That is different than forfeiture, which is the failure to make a timely assertion of a right. Waiver extinguishes any error, forfeiture does not. There is no example of waiver in this case. There is no thing where, there's any evidence that trial counsel knew of the objection they should have made and said, I'm not going to make it for a strategic decision. That is not the case here. The court sees most examples of waiver being entering a plea and waiving the right to a trial, or waiving the presence of an attorney and things like that. Those are complicated, intentional, knowing processes, and that's not what we have here. This was at most forfeiture, but when it comes down to it, it's not even that, because forfeiture is defined as a failure to make the timely assertion of a right. However, this motion is the timely assertion of that right. MCR 6.429C states, a party shall not raise on appeal an issue challenging the scoring and sentencing guidelines or challenging the accuracy of information relied upon in determining a sentence that is not within the appropriate guideline sentence range unless the party has raised the issue at sentencing in a proper motion for resentencing, which is what we're doing here, or in a proper motion to remand filed in the Court of Appeals. Under the court rule, we are in fact preserving these issues for appeal. So saying that they were waived by counsel is not accurate. This is why it's not necessary to, in every case, to assert ineffective assistance of counsel, which plaintiff counsel agrees I could actually do in the same exact form and say, you screwed up by doing all these things. But what counsel did on the record is not a knowing, intelligent waiver of that right. At worst, it could be forfeiture, which does not waive the issues.
Which does not waive the issues?
Correct. Plaintiff relies on an unpublished case of, again, of Marnie. To the contrary, but again, Marnie does not stand for what the plaintiff asserts. In that case, the defendant simply alleged the court relied on something incorrect without pointing out anything actually incorrect. This is not the court relied on incorrect information. This is in this situation, these were scored incorrectly, usually because of whether they're McGraw variable or not. So to attempt to avoid any semblance of due process, the plaintiff would just have this court overturn the court rules and try to apply for such.
Would he have this court, what the court rules?
Overturn the court rules that try to provide for such. Regarding OB3, plaintiff again argues waiver. At no time did trial counsel expressly withdraw his objection or state satisfaction with the court's decision. Court asked if the prosecutor was asking if the scoring stayed at 10 points. The plaintiff requested such, and trial counsel was instructed to move on by the court. Addressing the merits, the plaintiff argued Mr. El-Amin strangled and hit her while inside the dwelling. The problem is that is a different crime that day. The order of events was he was there lawfully overnight, strangled her, then left. What happened is he comes back later, wants to be let in. She won't let him in, so he breaks and enters. He opens a window to unlock the door. The strangling had concluded prior to any part of the home invasion had started. It's not a situation where I'm trying to nitpick the situation. These are two separate, distinct events. Because this is a McGraw variable, we have to look at the sentencing offense, which is the home invasion. There was no physical contact testified to with regards to the home invasion. Strangling, horrible, different crimes scored on that crime, not scored with regards to the home invasion. OB7 is also McGraw variable, which means it's limited to the crime being scored. Again, the plaintiff is
to the what?
crime being scored. Sorry. Again, the plaintiff asserts the choking happened during the home invasion. It did not. He relies upon the strangling that happened before he reported left and then broke back in, which started the home invasion. With regards to the felonious assault with wiping the blood on her, as plaintiff's counsel accurately says, when it comes down to it, these aren't going to be dictating the sentence itself for the felonious assault. But smearing blood on her is not enough because there's not enough on the record to support such. Plaintiff asserts in their brief that smearing blood was intended to substantially increase the victim's fear and something that he accomplished quite well. There's nothing in the record to support either of those things. It's not like we have a statement from him saying he did this. It's not a statement from her saying that this scared her. It grossed her out because it is gross. Plaintiff tries to rely on, and again, an inapplicable unpublished case of Bradshaw, where the victim was repeatedly beat with a baseball bat in his fist over a period of a half hour. That's not what happened here. The rest of the plaintiff's argument is basically that OB7 is not a McGraw variable, citing in 2005, once again.
Now, so you've got to slow down.
I apologize, Your Honor. Saying that OB7 is not a McGraw variable, trying to rely upon an unpublished case from 2005, which is not binding on this court. It also predates Rodriguez, which is a published case by the Court of Appeals, that says that McGraw, this is a McGraw variable. So we have case law that is relevant, saying that you have to look at the crime for OB7, and plaintiff's counsel just kind of ignores that and cites an unpublished case from 12 years earlier. With regards to OB10, again, plaintiff cites to a non-binding unpublished case. The binding law cited in our motion is clear. The mere existence of a domestic relationship is not enough on its own to equate victim vulnerability. Point should only be assessed when it is readily apparent that a victim was vulnerable, i.e. was susceptible to injury, physical restraint, persuasion, or temptation. It also requires exploitation of that vulnerability. Here, he tried to come back and tried the door. It was locked, so he reached in through a window. There was no testimony that they had ever done this before. This is something he knew because of the relationship. They had never done it together. He didn't know that it would even work. He's trying to get in her testimony as she is on the phone with her sister on the couch, basically watching him do this until he gets in, and then he creates havoc. He starts putting water on her stuff. He starts trying to get her to leave, all these horrible things. But when it comes down to it, this is not a situation where he's manipulating her to try to get her, manipulating that relationship. It's not that he's actively exploiting her, grabbing her by the shirt and saying, unlock the door, or else, something like that, where he draws her in close when using the domestic relationship. Even if this is something they've done before, this is how they always get in house, I would absolutely not be making this argument because that's using his prior knowledge. He did what anyone could have done, and there's no evidence that he used some knowledge from the domestic relationship. The existence isn't enough. And there's no evidence that he actually exploited that victim in some way in order to gain access. He broke in.
He broke into a home where there was a known relationship and he felt he had an entitlement. Doesn't that belie some of your arguments? I mean, people in relationships get close because they're in a relationship.
Correct. And I think that if she was not home, I think that the court's argument it just made could just as equally apply because he didn't do anything to actually interact with her in any way, shape, or form. It has to be exploiting her for it to be scored under this very law, which is the case law. I apologize.
And you don't think his actions exploited her, placed her in fear, demeaned her, manipulated her, none of those things?
I would say that they placed her in fear 100%, Your Honor. But it requires exploitation. There was nothing about what he did that exploited the domestic relationship. Like I said, she could have been absent and he could have done the exact same thing. And she can't be exploited in a place she's not at, Your Honor. Finally, with regards to OB16, the plaintiff essentially concedes there was no damage over $200 and that should have been scored at 0 points instead of 1. It doesn't change anything on its own, but I feel like I have to make sure to make that clear for them. Thank you.
Response?
Well, let's see, let's start with the PRBs. Right on page sentencing transcript, let's see, page 14. You have any other objections? Not on the PRBs, as the courts have said that is a waiver. And even if it's not a waiver, let's take away those points. Oh, guess what? The guideline range doesn't change. So that's a non-issue. So we have nothing with PRB 5. Yes, the guidelines should be changed to eliminate those points, yes. However, then it's not entitled to a resentencing. Even if the issue is totally preserved, it doesn't change the prior record level, the total, it's still the same. Now, going on to the others. The defendant actually withdrew his claim on OB3. But then let's just not worry about that. See, strangled and hit the victim, causing her to black out while in the building. Well, actually, to almost black out. That's enough. That's enough there. Then we go on to OB7. That's very interesting. When the defendant was talking about OV10, he said, oh yeah, 100% there was fear. Well, that's kind of, that he intended fear. Well, that's kind of what we're talking about here. And defendant incorrectly says that you can't use any, or he certainly has no case or any law that you can't use the facts of the other crime when they are all done at the same time. And besides, smearing his blood on her face is horrendous. That by itself takes care of all of them. Now, OV10, defendant miscites what the rules say on that. They don't say that it has to be more. No. The mere existence of one or more of the factors described does not automatically equate with victim vulnerability. That's very different from what the defendant said. And in this case, as all the cases say, the mere fact that there is the relationship, he wouldn't have been there otherwise. He wouldn't have gone in otherwise. So that was properly scored 2. So I'm asking Your Honor to deny the motion for resentencing.
Let me ask you, Counselor, if you acquiesced on OB5, right? But it doesn't change the total. I'm sorry, PR5.
Yes.
So that would be a 0, which would change it to 30 instead of, and it would still be a level D and not change anything, right?
That's correct.
So if it's in his favor, it doesn't change anything. That's not necessarily a resentencing where we have to bring him in, is it?
That is correct.
All
That
right.
is just an administrative adjustment. That's all it is.
Okay. Any final word, counsel?
Yes, Your Honor. Plaintiff's counsel again repeatedly misrepresents the facts and the law. We both briefed it. I know the court has read those briefs. We believe that the scoring should be upheld, and it does change the guidelines on the home invasion, the most serious charge, when those guidelines are properly adjusted. Plaintiff again is completely denying that McGraw exists. The case law is quite clear. The plaintiff's counsel can disagree with it, say it's limited, but many variables are in fact McGraw variables, as held by people v. Rodriguez. So we would just ask that the court apply the law, which will change his guidelines and require resentencing. Thank you.
I would agree with the statements of the prosecutor. This was a continuous act, and this case was a horrifying situation. I was just reminding myself in looking at the pre-sentence investigation report, defendant explained to the victim he was going to kill her and then himself on his deceased brother's grave. Everything he did was to intensify his control over her, his demeaning of her, her fear. These scorings are appropriate. I'm not changing them with the exception of variable 5. I think that does warrant changing. It doesn't affect anything. So as to PRV 5, that is now 0. The total is then 30. It remains then a level D. It doesn't change anything. The basic information sheet should be changed and the numbers changed, but I'm not changing anything on this file. I remember it well. This was a horrifying experience. I disagree with the interpretation of defense, and then leave it in the capable hands of the appellate courts, who I am sure are the next people who are going to review this massive record.
Your Honor, briefly, I believe there's also an agreement that OV 16 would be properly 0, just so neither one of us have to brief it.
Great, OV 16 0. And then that changes the scoring as well, but again, doesn't change anything, correct?
Yes.
And I'm sorry, which count was that on? Because we did the OV 16 on interference with electronic communications was 0.
I believe it's the home invasion, Your Honor. I believe that was one of, yeah, that was one.
Yeah, oh, there it is, okay. OV 16, yeah, it goes from 1 to 0 now, so the total is 120. So that should be corrected. All right, I've changed total PRVs and OVs, and we're still in the same exact situation, so. All right, any further?
Nothing from the defense. Your
Well, and let me just be clear, the PRVs are being changed to 0 on all of the ones with their 5, is that correct?
Should be.
Yeah. The record should reflect that I changed all of them to 0, and then doesn't change anything, but it goes to, so on the unlawful imprisonment, assault with intent, that all changes the total of 30. However, then we go to, and then assault with dangerous weapon would be 30 and PRV 0. But then I think there's one that it does change it a little bit lower. Just make sure. So on assault with a dangerous weapon, also known as felonious assault, that would be a total of 20. Does that change it?
You're off with the words, Your Honor, I apologize.
And then also we have assault with intent to agree about the harm less than murder by strangulation. If the PRV 0, that again goes to 20. So just need to make sure. And then there's 2 counts of, there's an assault with intent to agree about the harm less than murder by strangulation, changing it to 0, and then the total PRV is to 20. So there's 3. Nope. So we have unlawful imprisonment. That then goes to 20. I just need to make sure that's still level D and doesn't change anything else.
Okay, now.
So half of them are
Okay,
30 and half are 20.
okay, now. Let's go to the grids. Okay, felonious assault is an F, isn't it? Okay. For a level, OV level 2, that's 10 to 34.
Let me just see. What are we on? We're on.
The felonious assault.
Okay, yeah.
A level, a class F, level
I'm
2.
changing the D to F. Level 2.
Level 2.
On the
For
offense.
a class F offense is 10 to 34.
Okay.
So if it was 30. Oh, we're talking PRVs. Okay,
PRVs.
I'm sorry.
Yeah, that's where I'm confused. Okay.
PRVs, okay. What was the number and what is it now?
It was 25 and now it's 20.
Okay, that does drop it.
To
Okay, what was the,
It was a level D.
okay, that's a D. What was the OB level?
The OB level was 135 and it was a level 4.
Okay, a level 4, of course it was, yeah, okay, now. Since we're not talking habitual offender, the new guideline range is 5 to 23 instead of 12 to 24.
No, I had 5 to 23 on felonious assault.
Well, that's 10 to 24 points.
It's not gonna make any difference, I'm not gonna change it, because I guess I could change it, then we gotta bring him here, that actually makes it better but worse, I don't know how that happens.
Yes, yes, I understand. The thing is, it does not change the important one,
Right.
the home
so-
invasion. So
Right,
it wouldn't do, so even if you completely wiped out all the others except for the felony firearm,
okay, so,
it wouldn't affect his,
so that was scored erroneously. So even by doing the 20 and the level, it's still a level D, you said?
well, it's a level, a PRV level is C.
Oh, sorry,
Because,
C.
yes,
Then we have 135 in the OBs and it's a level 4, so the guideline range was 5 to 23, but it should be 10 to 24.
no, it should be 5 to 23.
Oh, so then that's correct.
Yes,
Okay, so we got that, good.
okay, let's see now. The
So now we
floors-
go to assault with intent.
Okay, assault with intent to, okay, assault GBH, let's see, that would be a C offense, wouldn't it?
Yeah, and then
Okay,
34
oh,
to
it's a
60,
D, okay,
that's a D.
okay,
Assault GBH.
Assault GBH with a PRV 20.
okay, just a moment, I can check this up, let's see
They
now.
did have it at D.
Okay, if it's a D offense, fine. And we had 30 points, what was guideline range?
34 to 67.
Okay, it drops down here. Okay, the new range is 29 to 57.
Okay, I can need that change.
Okay, let's see now, that was, let's see, for, okay, that's count 4. In count 4, you gave 5 to 10, which means it's 3 months over the guidelines now, okay. And
So we're all running concurrent, it's not gonna change anything, right?
that is true, it will not change the minimum out date, that is true.
I mean, I can lower that one 3 months, it's not gonna make any difference.
I would not object to your lowering it 3
Great.
months.
On that count, we'll lower it 3 months.
Okay.
So it will now go to
57 months.
57 months, and that is, I'm sorry, count.
Count 5, no, I'm sorry, 4, count 4.
So
Oh,
count 4 is now 57 months.
and I believe that's also, would that also be count 12 and 13?
Yes, count 12 and 13, so now count 4, 12 and 13, instead of 60
Okay.
months, is 57 to 120 months.
Your Honor, Adam Pfeiffer on behalf of the people, just to clarify, the PRV being lower, that's only for the charges from the 924 incident, correct?
Yes, which is, well,
No, not the PRV, the OV.
it's it's,
PRV is for everything.
Got it.
Okay. Yeah, since the PRV drop absolutely everything.
so I've corrected the sentencing guideline sheet, and also my sentencing, and since we've again made it better for him, I don't know that he needs to be here.
Okay, unlawful imprisonment, that which is count 3, let's see now. Okay, what is that? Is that a C? Okay, that's a C.
Secret.
So let's see what that does. Yep, it drops it down to, instead of 50 to 100, it's now 43 to 86. And let's see now, 8 years, 4 months, so that's 72, 76. Yeah, no, 8 times 12. 96. 96, that's 100. So it's now 14 months over the guidelines. I would not object to reducing that one
Okay,
to 86 months to 15 years.
and that would be count 3?
3, that's right.
So now it's 86 months on both the unlawful imprisonment, right?
On,
Count 3 and count 14,
you're right, there is a 14 too. Yes, it would be for both.
be 86 to 180 months.
Yes.
Okay,
This is, okay, hold on, Your Honor, this is what I thought. So the PRV 5, it does not change for 2, 3, 4, 5, and 6. Those shouldn't be altered. We've been talking about 3, been talking about 4, but that PRV level doesn't change. Those
So,
should remain the same.
we've left count 2.
3, 4, 5, and 6 should remain unchanged.
Okay.
We're talking
Wait,
about
wait, 2, 3, 4, 5, 6, or 3, 4, 5?
2, 3, 4, 5, 6.
Well, yeah, come to think of it, that's in defendant's motion himself.
Yep.
He says it does not change on those.
That's what I thought was happening, because
Oh.
it's split between the 2 incident dates. So these changes should only be affecting 8, 12, 13, and 14.
8? No, we've decided this does not affect 8.
Okay.
And it does not affect 2.
12, 13,
So-
14.
Yes, 12, 13, 14 then. This can all be reduced.
Yep.
Okay, so
I got you. Sadly, I remember
12,
this case.
13, okay, so then 4 remains 60 to 120.
Yes.
However, 12 and 13 are 57 to 120.
12 and 13, yes.
Yep, and then we go to
14,
14, which is
86,
86 to 180 months.
yes.
However, count 3 remains the 100 months to 180 months,
Yes.
and count, let's see, count 2 is 140 months to 240 months, right? That's
Yes.
what I had. And then count 5 is,
Count
I
5
think
stays
it's
at
at
2 to 4
60.
years. Okay, that stays.
that was, count 5, wait, count 5 is, yes, 2 to 4 years, and count 6 is
1 year, 4 months to
16
2
months.
years.
Yeah, 16 months to 24 months? Or, yep, or no?
Yes, that stays the same.
Okay, so I think we've got it.
I would add 2 things. In our motion, we allege that conviction 8 should also be affected by the PRV change. Second, I'm objecting to all this, and I'm not waiving any rights with regards to these, because the court has made its decision, and I'm not trying to do that.
That's
So
fine,
Make it clear, it's not waived.
so 8 has 57 to 120 months, and 6 has 57 to 120 months, right, or no?
So,
So it's 12, 13, 14, 8, and 6.
no,
6 should not be changed with regards to PRV 5, Your Honor, but
I'm sorry.
8 should be, the offense is dispensed with.
Oh, wait a minute.
can I grab
Yeah,
the puck for 1 second?
is it 8? 8 should be 57 to 120.
Now, let's see, 8 is a felonious assault, which is an
No, 8,
F grade.
wait, I'm sorry, wait.
Give me,
13, I'm looking at the wrong one, so. Assault within the, yeah, so that's 24 to 48.
Yes,
That's-
but the
that's the
proper
prior
guideline range for that is 5 to 23.
So that should be, so 8 should be 23.
Okay, I see, I
Right?
see. Okay, I have no objection to reducing that down one.
Okay, great. We did that. I think we did it all. It's a lot of math. We might need, I'm sorry, I just want to address the clerk. Did you get all that?
I was usually gonna wait till you're.
Yeah, my notes are, I think after this, if you could meet with council, they'll.
can you put the puck up there for a second,
No,
please?
maybe.
This is simply to help as a visual aid.
And I was just gonna ask for the updated scoring and judgment of sentence at the end, because
Yes, we are gonna get that.
I can't keep that straight either.
And your objections are preserved, but this is in his favor, so he doesn't need to be here. It's not changing anything. So,
Actually, the puck died on. First time it's failed me in this courtroom.
it's been one
Try another
of
one.
these weeks.
It's weird.
It's blinking too, so it's.
I know. Nope, don't worry about it. I still have my breakdown from the sentencing of what charges are and what dates. I was always gonna put up there because that helps clarify.
Goes here, we drop by 5, so then we drop. As far as the exact number.
Requesting transcript.
We're gonna drop to judgment.
Yep, you need that.
Yeah.
Yeah, defense needs that.
I don't get it.
Oh, you did it anyways, though.
Yes, I appreciate that.
It's how many days? Oh,
Think about 365.
oh, that's wonderful. That's almost as many words per minute.
We have it straightened out, so one person can just read it for the
I think
record.
it's 14.
Okay. I can read it for the rest.
Great, thank you.
Okay. The motion for a new trial is denied. The motion for resentencing is denied. PRV 5 is reduced as to the crimes that occurred on the first date, but not as to the second date. And OV 16 is reduced to a 0. Oh yeah, PRV 5 is down to a, what is that, down to a 0, yeah.
Yes.
And OV 16 is a 0 whenever it was calculated on whichever. Now, in addition, count 8, felonious assault, is reduced to 23 months to 4 years. Count
48 months.
Yeah, 23 months to 4 years. Count 12, strangulation, is reduced to 57 months to 10 years.
Or 20 months.
Yes, as is count 13, also a strangulation, 57 to 120 months. And count 14, unlawful imprisonment, is reduced to 86 to 180 months. That's it.
Your Honor, just for clarifying the record, my understanding is the court, other than those changes, believes the guidelines were correctly scored before, but not as an issue of because they were waived. Is that the court's ruling? Just so I know what to brief in the Court of Appeals.
Yes, however, the ones we corrected I'm agreeing because but they don't change, I mean, they changed something minor, but the other ones remain.
Okay, and I'm just clarifying because I won't initially brief the waiver issue. If he brings up, then I'll respond, but I just want to make sure to narrow as much as we can the issues for the Court of Appeals.
So, but the PRV 5 shouldn't be an issue anymore, where we've changed it, and OB 16 shouldn't be an issue where we changed it. That's moot.
Correct. He just asserted waiver on other variables. I just want to make clear I understand the court's rule.
That is true, but there is no waiver on OB7. That is fully preserved for appeal. It's just that the other side reclaimed waiver.
Okay, are we clear?
I think the record is clear.
Okay, and who's preparing the order? Mr. Wickman, are you?
I can do 2 orders denying the 2 motions of court wants without an evidentiary hearing. I'll send it to the prosecution to make sure that I include good language on it, and we'll get it to the court for signature.
Great, thank you.
And one more thing, I've already sent to council.
Correct.
The receipts on restitution.
Perfect.
Yep, and I confirm I received it. It was received by their office January 15th, 2016 at 10:15 a.m. I do have 3 attachments to that. Yes, 3. That currently can't load, but it's probably an internet issue. I'll let him know if I can't open them.
Perfect.
Worst comes to worst, I'll print it and I'll hand it to you.
You're gonna
long before the hearing.